What if I told you that 2 hours of traffic could cost you your green card, your asylum case, even your right to stay in America? For years, immigration courts have treated traffic as an automatic excuse that simply didn't matter. You were late, case closed, deportation ordered. But now, in a powerful new decision, the Ninth Circuit has changed the rules. The Ninth Circuit says immigration judges can't deport someone if being stuck in traffic is their one and only excuse. This decision came from the full court, not just a panel of 3 judges, which makes it very powerful. The court said traffic is not automatically good enough, but it's also not automatically rejected. Judges must look deeper. That's a major shift in how these cases are handled. Totality of circumstances now controls in the Ninth Circuit. You have to look at the whole picture. This changes how missed hearings are reviewed. The focus is no longer on one word like traffic. The focus is on the whole situation. What happened? Why did it happen? And whether it was truly out of the person's control. You're stuck in traffic? The Ninth Circuit says judges must actually listen. Before, many people felt no one was listening. If you said traffic, that was it. Your case was over. Now, judges must actually consider the facts. They must listen. What if you're on a freeway between 2 exits, stuck in your car, and your car doesn't fly? You're stuck, right? Why would you get deported for that? This was a major decision from the Ninth Circuit. The court says immigration judges can't use blanket rules that traffic never is good enough. In the past, many cases were denied quickly when someone missed court because of traffic. Judges often treated traffic as something normal and very predictable. The Ninth Circuit said that approach is wrong. The law requires a closer look. The court explained that judges must look at all the facts. They have to ask themselves, did the event actually cause the person to miss the court? Was it beyond the person's control? And was it serious enough to meet the high standard that the law requires? Traffic is not automatically good enough, but it's also not automatically disqualified. This decision changes how these cases must be analyzed in the Ninth Circuit. What was the law before, you ask? Everyday problems were not good enough. Normal transportation issues like traffic usually did not qualify. The message was simple: plan ahead, leave early, expect delays. That happens, especially in cities like Los Angeles. In this case, a mother and her children were going to court in Seattle. They left 2 hours early, and they had a hearing at 8:30 in the morning. On the way there, they ran into 2 major car accidents. Traffic backed up for miles. The trip took them almost twice as long as expected. They arrived 2 hours late. The deed was done. They had been ordered deported. They took photos. They saved the news reports about the accident, and they quickly asked the court to reopen their case. The immigration judge said no. The judge treated traffic as not good enough. The appeals Board of Immigration Appeals, agreed with the judge. What should you do if this happens to you? This case shows that something very simple has to be done. Proof matters. Photos, news articles, GPS records, detailed sworn statement, evidence that the person filed quickly to reopen the case, and evidence that they attended the hearings in the past. It is not enough to say there was traffic. You must show what happened and why it was truly outside your control. Does it have a broader national impact? Does it lower the burden now for everyone? No, absolutely not. The standard is still very high. You still need something beyond normal. You have to show it was serious enough and it was beyond your control. What changed is that the judges cannot use shortcuts anymore. It raises the fairness concerns. Yes, in a quiet way, the court says each case deserves real consideration. This is about fairness. Is there a split with other circuits? Most circuits agree with the issue of fairness. Now, not all circuits have litigated this issue, but I'm sure they will. And eventually, I think they will all reach this decision that human beings get stuck in traffic and you can't deny their case simply because of them. What are the key takeaways from this? There is no automatic rule that traffic can never qualify. Judges must look at the full picture on a case-by-case basis. The reason must cause the absence as a major reason, and it must be out of the person's control. The standard is still very strict, but automatic denials are no longer acceptable in the Ninth Circuit.